back, everybody, to the California Small Farm Conference. My name is Evan Wigg with Community Alliance of Family Farmers. We're excited to have you here for a workshop that is called Legal and Business Considerations for Non-Farm Income. So thanks so much for being with us this afternoon. And it's my pleasure to introduce Rachel Armstrong from the Farm Commons. And before I pass the mic over, just a reminder to all of our attendees that we've got the chat and QA functions down below if you want to ask a question for today's panelists, or if you'd like to join in the conversation, just type it on there in the chat. Today's workshop is going to be recorded, and we're going to post that up on CAF's YouTube channel with all the other amazing Small Farm Conference workshops. So check that out. We'll send a link after the conference, so keep an eye out for that. And with that, thank you so much for being here, and I'll let you take it away.
Thanks, Evan. I want to just say a quick word before I hand it over to Rachel, but I'm Elizabeth Vaughn at Community Alliance of Family Farmers. And we're really excited to have this session today. Rachel and the organization that she represents, Farm Commons, has been an amazing partner to CAF and to many of our small farmers. So we're wanting to lift up her knowledge, her resources, her expertise on a lot of really challenging topics that come up for farmers all the time, whether it's how do you report various taxes, land use policies, employment law. So we're really excited to have Rachel here today to talk to these topics. This also is a benefit to some of our Innovation Challenge applicants as well that I'd like to share. They've developed some amazing intellectual property, and they're curious how they could maybe protect it without spending so much money on a patent or a trademark. So she's also planning to cover some of those topics as well in case you have a invention or idea that you're interested in exploring for additional income. So Rachel, I'll hand it over to you to introduce yourself more. And if you have any questions, please put them in the chat or in the Q&A as they come up, and Rachel will take some time throughout the presentation to address those. All right, Rachel, thanks for joining us today.
All right. Thank you, Elizabeth. I am going to share my screen and we'll get things started. So good to have you all here today. Legal and business considerations for non-farm income. Now, my name is Rachel Armstrong, and my nonprofit is Farm Commons. And if you aren't familiar with us, our mission is to empower agricultural communities to address their own legal vulnerabilities within an ecosystem of support. So what that looks like day to day is a lot of educational resources. We write guides, we host workshops, do webinars, have a podcast. We have a question and answer platform. All sorts of things to help you understand the law. We also believe that farmers are the best source of solutions to their legal challenges, and so we also do leadership development. In communities, we help farmers understand their own wisdom, give them platforms to help share that with others, and create community conversations around farm law issues. We're a membership organization. And my name is Rachel Armstrong. I'm the executive director of Farm Commons, and I also founded the organization. I think it was 13 years ago, every year I forget to update that number, but that's where I think we're at. I'm joining you from Duluth, Minnesota, and this is where my family, going way back, has farmed for a long time. It was cabbages and potatoes back in the day on cutover land after the logging companies went through. So farming, took a real hit in the 80s after I was born, and so that's not a thing my family does anymore. But you know how it is. Once a farm, always a farm. That heritage stayed strong. Okay, so today we're going to be talking about when you want to add another venture to your farm. We call this diversification a lot of times. We're diversifying our farm income. And so I'm going to clarify, some of the things that we're talking about. When I talk about non-farm, or income, what do I mean? I mean all kinds of things that could be really great for your business, like starting educational programming. Maybe you want to do a school-aged class, or maybe you prefer to teach adults flower arranging, all kinds of classes that you could do. Value-added products. Those are things like jam from your berries, freeze drying, dehydrating, on-farm farmstead dairy. But also there is plenty of potential for farmers to add things like arts and crafts. Many farmers also have artistic skills and want to create those products to sell as well. Maybe you have expertise in a certain area and you'd like to provide services to others, or general farm business consulting, perhaps drawing on some educational background you have or just an expertise you've developed. Many farmers are developing special tools, machinery. Maybe they're manufacturing their own custom implement or hand tool, or they might have discovered something abroad that now they want to import. Software is certainly another category where farmers are developing new ways of achieving efficiency in their operations, and they want to sell that to others. There's a lot of good reasons to develop these sides of your enterprise, but there's also a lot to know about taking on these other aspects of the farm operation, of diversifying in these ways. So my presentation to you today, everything I have to tell you relates to all kinds of for-profit non-farm diversification ventures, whatever it is you're doing, from preschool to importing a new piece of equipment. This all is going to relate. The core thread that I'm pulling on, though, is I'm assuming that you are starting with a farm business. I'm assuming that the core thing you started out doing a few years ago was farming, and then from there you are diversifying into other avenues of goods and services and products that you want to sell. Now, that would not be important for me to say, but for farming is unique. Farming is different in a lot of areas of law. And so this weird thing happens when we start not farming, when we start non-farm ventures, that all of a sudden the rules change. Let me tell you, if you don't start with farming, it's not that weird. You're just like running a different business, but the same rules apply. It really is the oddest for people who start in farming and then extend into other kinds of ventures, because the rules are changing underneath them, and a lot of farmers just don't realize that the rules will change when they go non-farm. So if you talk to your coffee shop owning peer who's like, well, yeah, I started teaching art classes at night. It was no problem. Just do it. Okay, that's because they were running a coffee shop. It is different if you start with farming. Okay, so our roadmap for our time here. We're going to talk about, what do I have here? 6 things. Starting with zoning and land use. We'll go on to employment law. We'll address insurance and liability changes, tax and accounting particulars. I'll review intellectual property protection. I'm not going to handle patent very closely. I'm going to give you like five different types of intellectual property protection that you might consider, but details on, none of them. Then I'll touch on business structures and whether you want to run your new venture out of your same LLC or whether you should consider doing a second one. So that's the breadth of topics that we will be addressing. While I go, please ask your questions. I love when people, ask their questions as they come up during the conversation. The chat box is there for you. I have that open, and that's probably the easiest way for me to catch your question. I don't know if we have the ability to raise hand, but that would be another option where you can do that. Let me, let me know if you need another mechanism besides chatting. All right, so let's get a little deeper into zoning and land use considerations. So there are a number of different land use restrictions that can prevent you from using your land for all types or any type of non-agricultural use. These things we need to consider are, number 1, the zoning code. Number 2, do we have any conservation easements on the land? Number 3, do we have any covenants on the deed to the land? Number 4, any leases. Each of these mechanisms can restrict how we use our land for non-agricultural purposes. assuming right now you're using it for farming and you're good to use it for farming. So that's my assumption is you know you're good to use it for farming. You've been doing it. It's can you do these other things? So we're going to start with zoning. First, what are your zoning regulations? Zoning is composed of two parts. First, you have a map that assigns each property into a zone. These zones usually go by acronyms like A1 or R3 or something like that. And then for each zone, A1, R3, there's a list of things you can or cannot do within that zone. So in order to proceed with this, the first thing you got to do is go locate your property on a zoning map, the property that you're going to use for this expanded venture. You can do this by contacting the county clerk, the zoning office in the municipality where you are. It really does depend on like who governs the zoning for where you're at. And your goal is to figure out what is the zone that you're in. And then you need to look up the code. You can certainly search online, and the appropriate local government website will often include links to both the maps and the accompanying code that describes what is allowed in there. Occasionally, we do see places where things aren't online, and you might need to go down to the office to flip through an actual book to figure out what the map and the associated code is, but that's not common. If you have any hesitations about finding your property on a zoning map, or you just don't feel comfortable with this, you can also ask a reference librarian at a local public library. They're a great resource and can help you find what you need. And that can be especially powerful if you just don't want to interact with the zoning authorities yourself. Now, usually when you're looking at your zoning code, you have something in mind. You have an adventure and a venture you want to start. Like, I want to manufacture this tool. I want to begin offering preschool classes. So you are going to look in the code and hope to find something that says offering preschool classes is totally fine. Or, well, you can't manufacture anything in this zone. That's the best case scenario. It's going to name the venture you want to undertake specifically and identify if it's allowed or not. But sometimes life is not that easy. Sometimes you go to the code and you find it's allowed under some conditions, or you might find it's not allowed. Worst of all, you might find it's never mentioned at all. That last one can be really frustrating because, what you want to do might be unique. They may not have entertained the idea that somebody was going to think about doing that in your area. And so they didn't think to either allow it or prohibit it. And so you're kind of stuck in this in-between area. At this point, zoning turns a little bit into an art rather than a science. And when I say art, I mean a little bit more like a political art kind of thing. What this means is that you might be shaking some hands in the near future. What you might need to do is figure out who are the decision makers in the zoning office or regulatory authority right now. What are their concerns? What do they see for the future of your community? What's their vision for agricultural sustainability, an agricultural economy where you are? Is there something that they might like about your plan? Is there something that might bother them about it? Once you know who's in charge and what is important to them, you can help to tailor your plan in a way that is going to suit their vision for the community. So exactly how you go about that can be complicated. That's where the finesse comes in to figure out where the priorities are and how to align your desire within those priorities. Sometimes we have an opportunity like you may need to apply for a permit or ask for permission. And that can actually be a really good thing because it gives you specific parameters to shape your venture around what they want to see. Like, how are you handling wastewater? Is there going to be, a need for parking or deliveries? What are you going to do to make sure that that happens in a way that works for the community? Okay. So zoning is one, but there are these other land use controls that I want to make sure we talk about. Conservation easements. These are restrictions on the use of the land that are meant to protect it from development and preserve its use for agriculture in many cases. Could also, of course, preserve it for endangered species, habitat, that kind of stuff. But it has a purpose. So what you need to remember when you have a conservation easement on your land is that it allows farming right now, but what you're thinking about is probably not farming. All those things I listed, like turning, or selling a tool or hosting preschool classes, that's commercial. It's generally considered commercial. You're selling regular old goods and services at that point. Even if you're just sitting in your office developing a software product, that is not considered a farming part use of the land. So you need to check the language of your conservation easement and read what is allowed and what is not. This is something that you should have a copy of since it has big implications for how you use the land on which you are. But you can also ask the easement holder for a copy or even check with the land records office to see if there's a copy on the deed. The same thing goes for covenants. Covenants are attached to the deed, and those you really do need to go to the land records office to find those restrictions if you don't have a copy of them. Usually deeds have a beneficiary, like a neighborhood association, that also has a concern for what is in that covenant that you need to look at and figure out what it says. So conservation easements and covenants may be negotiable. Like if you don't like what it says, if it does prohibit the kind of operation, the kind of venture that you want on that land, you can go to the easement holder and say, look, in order for my farm to be viable, I need diverse income streams. I need to be able to sell this software product or do this consulting. And if it still upholds the values of the land for which it was protected, it's possible that they would amend the easement and allow you to continue with that. So things are usually most flexible when we're talking about a lease. A lease, we've got the landlord and we've got the leaseholder, and we can do that negotiation. And leases often, they renew on a yearly or 5-year basis. That gives us fresh opportunity to negotiate. Bottom line, though, is you got to know if you're going to be allowed to do that thing on the land that you're on. If you're not, you got to pursue an alternative. Find other land from which to conduct this new venture. If it is something like, manufacturing, there's probably commercial districts nearby where you could lease some space and do it there. Same with education. You may need to, go somewhere where you can have host preschool classes or flower arranging workshops. Awesome. I don't see any questions coming on land use yet, so we're going to roll on through to employment law. Okay, so the thing that is happening, that may be happening with your farm right now, is that you may be leveraging employment law exemptions that are available in the state of California for farms. That's going to end. Once you start not farming, you do not qualify any longer for ag exemptions from farm employment law. So if you are not already, you will need to start paying at least $16.50 an hour for all the labor on that new venture. Okay, so if you're accustomed to hiring folks at $15 an hour and you go into your new venture thinking, well, this is this is not skilled labor. I just need a high school student. In the evenings, I'm going to keep with $15 an hour. Well, you can't. That's only available for ag workers. So at least $16.50. You need to start paying overtime for all hours worked over 40 in the week for non-agricultural labor. So let's say, again, you've been running your business for 5 years. You've become accustomed to not paying overtime at certain amounts, although that is about to change in California. So you probably heard about that. But, we need to be aware that once we step into non-ag, it's time and a half at all hours worked over 40 in the week. This becomes especially complex if you are using the same employees for farming as not farming. So your farm employees, if they, help you out with your consulting enterprise or work with you on your import business, again, that exemption is lost for all the overtime that they may have done for the farm. So let's say you use them for 3 hours on a Tuesday afternoon to help you, unbox your latest load of imports. Now, when they go to the farmer's market on Saturday, and that pushes them into hours 41, 42, and 43 for the week, those hours are at overtime because during that week, they perform non-agricultural labor. If you are not already paying into the unemployment insurance tax system, you will need to start. Unemployment insurance tax kicks in right away for your non-ag labor. So fundamentally what this does is just raise the cost of doing business. It's, hopefully not a bad thing. Hopefully this venture is something that is going to make you money and that has profitability, and that these increased costs will not be a barrier to the success of your operation. They are just something to keep in mind. They are something that can trip up folks who are familiar with agricultural employment rules and don't realize that the stuff changes.
And Rachel, there was a clarification in the chat on explaining that again with the non-ag to ag work.
Sure. Yeah, so agriculture is the raising of crops and livestock, and the things that are immediately necessary to bring that crop or livestock to market. So agriculture is planting seeds, weeding, watering, harvesting that product, taking care of animals. It is even, it's things like fixing fences, irrigation, all that stuff that is really connected to crops and livestock. But what is not farming is really everything else. Even if you have an employee who works exclusively in packing and never does any harvest or anything out in the field, that individual can be seen as non-ag worker as well. And certainly the farther we get from that, the more likely it is that this person is not an ag employee. So in these ventures that we're talking about, to run back up to my list, these are not agricultural ventures. And so anyone who's doing this is not an agricultural worker. So non-agricultural rules apply. Okay, so question. So do we have to divide their work and how we pay, or they cross over into non-ag when they start and the ag? Okay, think of it this way. Non-ag contaminates the whole week. Okay, so you can have an agricultural worker who's the whole week, all they do is agricultural labor, and during that week, all the agricultural labor rules apply. So $6.50 minimum wage, different overtime rules, different threshold for unemployment insurance. But particularly for overtime rules, once that individual performs 1 hour of non-agricultural labor in that week, non-ag rules apply to the entire week, to all the time in that week. And what I'm explaining is federal law. So this is the case no matter where you are, the point at which these exemptions are lost. These exemptions are different depending on what state you're in. These are the California rules, but that's how you lose them. 1 hour of non-agricultural labor in that week. Okay, so someone says,
think that Q&A box, is that what you saw?
Yep. What about a person who does marketing or social media for the farm? So now a certain amount of marketing and social media that is really deeply connected to their farm labor. Like, let's say you have one employee who goes out to the fields with their cell phone and they snap pictures of harvest and they craft a quick Instagram post, post a short video of some cool harvest thing that you're doing. They, hit send or post or whatever it is you do, and then they keep going on with the harvest. And then later on, they snap a quick video in the truck as you drive to the next field, and they hit post. And it's just part of what they do, integrated, within their farm work. In that case, that's probably not going to contaminate the whole week. Now, on the other hand, we got someone who doesn't harvest anything. All they do is marketing and social media. They drive out to the fields to take the picture, and then they drive back to the office, and then they edit the video and post it, and now they're writing a newsletter. That's probably not farming. And that is probably not an agricultural position. And when we end up somewhere in the middle, that's where we're encountering risk. That's where we're taking a risk that this person is non-agricultural. And if we aren't following non-agricultural rules, we could get in trouble.
Thank you for those clarifications. And there was another question in the Q&A on just, I think, clarifying that creating a value-added product would be considered non-ag operations. So maybe just clarifying that, what type of employee that is.
Oh, sure. Yes. Thank you. Yes, creating a value-added product is non-agricultural. Yeah. Now, because I always have to raise the exceptions. There is some room for wiggle room, like, well, okay, but I'm milking the cows and that's going to get turned into a farmstead dairy, but I'm not working on the cheese yet. And, that's when we're getting in real deep. You might need to talk to someone. But to play it safe, assume that any time it's not directly related to production of crops and raising of livestock, it's non-agricultural. And of course, the easy way to go is just make sure you're paying at least minimum wage, overtime at 40 hours a week, pay into unemployment insurance. If you do those things, you don't have to worry whether it's ag or non-ag. So that's the quickest way. And I know plenty of farms are already doing all of those things, and they do not have to worry about whether it's ag or not ag. Okay, so bottom line is that your employment law obligations may shift. Your new venture will not get the exemptions from ag employment law that your farm may be utilizing. And if you use the same employees for your non-agricultural venture as for your farm, then your farm may also lose the exemptions. All right, so that's it for employment law. We got more to cover. Let's talk insurance and liability. All right, so injuries and losses. I bring this up because this is just a question I get asked all the time. And every time a farmer starts something new, they have to think about new avenues for loss and risk. Am I responsible if someone cuts the finger at my flower arranging workshop? What if my tool or my new implement injures someone? What if a customer loses business because my software had a bug and all of a sudden, credit cards weren't getting charged and they gave away a bunch of free product? Are you going to be responsible for that? Well, you might guess. It depends. It depends. Negligence is the primary claim that most folks would make in instances of injury and losses. So what is negligence? How do you become negligent? Well, to explain it real quickly, negligence is the failure to do what a reasonable person would have done under similar circumstances. Failure to do what a reasonable person under similar circumstances would have done. What does that mean? That's really not so helpful when you think about it. Like, what are similar circumstances. And how do I know what someone else would do? All I know is what I did. Well, that's why we go to courts, so that we get to argue about what the ordinary person in these circumstances would have done. And both sides are going to say, oh my God, a normal software developer would never have released that code. They didn't even edit it. That was terrible. Anybody would have caught that mistake. And the other side would say, oh my goodness, this mistake was buried in the code. I did everything a normal software developer does. And look, I'm sorry, the bug just snuck through, but it could happen to anybody. Which is it? I don't know. I guess the judge or jury will decide. And so very often what this means is it's hard to manage your behavior to avoid negligence. Instead, insurance. Insurance tends to be the solution for our worries and our concerns about negligence, liability, injuries, and losses. That's because then when someone comes to sue us and is like, I got hurt because of your product, I lost business, we say, okay, here's my insurance provider, please make a claim. And then what the insurance provider does is appoint an attorney. And that attorney will investigate, okay, what happened here? Are we actually going to be liable for this? Was this a problem? And, fundamentally what they do is negotiate and then try to settle the case. But if it does go to court, that attorney will help represent you on behalf of the insurance company. So insurance is a primary way that we manage this risk. And usually the business owner's core concern is not, am I going to be negligent, but did I buy insurance that covers what I'm doing? When you start from a farm perspective, you start with farm insurance. Farm insurance doesn't cover non-farming things. So when we start doing other adventures, we need to move to a commercial policy. Commercial policy is, a lot like a farm policy, but covers a range of commercial enterprises. These can also go by the acronym CGL for Commercial General Liability. These can be additions to a farm policy. They can be a substitute if the farm part, goes away or it's more cost effective. There's any number of ways to formulate the precise policy. The bottom line is you need it. And you talk to an insurance agent or broker as part of the business planning process. Start early. If you want to import a tool, you need to know what insurance is going to cost you for that tool. And that's going to depend on, how risky this tool is perceived to be. If it's a PTO unit hookup, it's going to cost you more. If it's a hand tool, it'll cost you less. So make sure you're securing quotes, talking with a range of insurance agents or brokers, and understanding that so that you're building that into, your cost of business. And, as business people, you probably already know this. It's just that sometimes we have to remind folks that insurance doesn't attach to your business. It attaches to the specific, commercial behavior that you're engaged in. Okay.
And we did have some questions, Rachel. There's one in the chat.
Excellent.
Yeah, about one person shared they're especially concerned about having people volunteer at the farm, friends and family who want to help with harvest day.
Yeah. So the facts on volunteers, they're simple to say, they can be hard to handle. The facts are that for-profit businesses cannot have volunteers. Anyone who does the work of a for-profit business is an employee, unless they're an independent contractor, but that's another matter. They're not volunteers, though. A volunteer is someone who donates their time and services to a governmental or nonprofit organization. So if your farm is organized as a nonprofit, you got a chance to have some volunteers, but for-profits can't. And they're going to have to deal with employment laws for anyone who is doing the work of their farm. So like I said, easy for me to say, that's the law. very difficult to implement because we know many wonderful farms out there who have, strong relationships in their community and run various volunteer aspects. But particularly in the state of California, there is enforcement of that. And there are definitely operations that have been shut down for things as seemingly pleasant and innocent as grape stomping festivals and things like that. Because if you got to get the grapes crushed, that's the work of the business. And anyone who's doing it is an employee.
Super helpful. Thank you for that. And there was another question that relates to liability that I'm wondering if I can ask that was submitted earlier.
Yeah.
It has to do with someone who has equipment that they're, trying to get to market, something they've invented, and they're doing demos, prototyping the equipment use, having other people test it out to give feedback. What's the best way to cover liability for those demos?
Talk to your insurance agent. Definitely. That is not uncommon. And the problem is, it's like, well, I haven't talked to an insurance agent yet because I'm not actually selling it. I'm getting input. I'm doing market testing. You still need insurance because that is the only way to really get robust coverage for what you're doing, unless you want to pay out of pocket, for an attorney to defend you, when somebody is injured at the demo. So just talk with an insurance agent and a broker. If you don't like the price that you're getting from one person, try another person and see if they know of a more cost-effective policy for the scale of your operations. If your revenue is still zero, that's going to factor into your risk exposure. That's going to lead to a less expensive policy. These things really are scaled to, your operation size, to your risk exposure. So if you're doing, 3 demo events a year and there's only 20 people who are coming, you should be able to find someone who can get you an appropriately scaled down policy to recognize that.
Okay. Yeah, thank you. Thank you for that. And then there's a couple other folks who are now chiming in the chat. So another farm is asking, is a standard farm liability policy at $1 million okay for these types of things?
That's always a very hard question to answer. I cannot tell you what is right for your level of risk exposure. I can say that from a legal perspective, if the claimant, the person who is injured, has a successful $2 million judgment against you and your insurance company only provides $1 million, technically speaking, they can still go to you for the rest of the $1 million. Whereas if you had a $2 million policy, your insurance would have covered it. I will say that is less common, that people would pursue you personally for that remainder, but they have a right to do it. So that's a tough one to figure out what's right for you, because of course, if you double to a 2 million policy, your premium goes up and you got to factor in where's your profitability. Okay.
Yeah, thank you for that. And then do you see this next one is on clarifying also on the educational events on a for-profit farm?
Yeah.
Your interpretation.
I know. So what happens here is I like give people a little window into farm employment law, and then they're like, what farm employment law? But unfortunately, I could spend an hour on farm employment law. So we're going to try to make it brief because we got more to go into. If you want a farm employment law hour, Elizabeth, I can get you one.
We can host that maybe in the future. Yes, let's plan on it.
Exactly. Okay. So I interpret that to mean you can't allow participants to practice agricultural activities as part of these events. Okay. Here's the phrase I use. They cannot do the work of your for-profit business. They cannot do productive work of your for-profit business. So if they're like goofing around with goats and like kind of getting a feel for it, and they're kind of like, you're just teaching them, it's just a workshop, they're kind of messing it up, this milk isn't going to be usable, oh, somebody splashed some hay in it, and but they're like getting a feel for it, they're probably not doing the productive work of your business. But if this is their 20th day of practice and they're like amazing now, and you're like, thank you for the milk, gonna go make the cheese, I think we've crossed a line here. So, we've got to assess their, are they doing the work of your for-profit business? Okay, someone says, what if you make them sign a liability waiver and they get hurt? Now, if you had an attorney draft that liability waiver for you and you told the attorney all of the particulars, like why are they there? Did they pay? Did you pay them? What exactly is going on? And that attorney advised you as to the exact limits of that liability waiver and its effectiveness, and you listened to that and you agreed and you signed it and you filed it, yeah, maybe it'll work. But if you didn't do that, don't count on it being there for you when you need it in court. Okay.
These are all really helpful. And I also just want to, if we can, maybe I can keep a tab on these. And if we have time at the end, we can get to the rest of these questions if you need to continue with your content. Rachel, so I'll leave that up to you. There's another question that came through in the Q&A too, so I can just make note of these.
Love the questions. Everybody's on the right track. Let's see if we can come back to them. I'm going to go tax and accounting now. Okay, so once you start non-agging, doing your other venture, your tax and accounting situation is going to change a little bit. So, tax and accounting basics. Profit and loss from farming is reported on Schedule F. Profit and loss from non-farming is reported on Schedule C. Unless it goes on Schedule E. Schedule E is rental income and things like that. So what I'm telling you is you got to know the schedule on which to place your profit and loss from your venture. For a lot of these other things that I mentioned on that list at the beginning, tools and manufacturing software, importing, education, it's basically Schedule C. So that's not hard. Come tax time, you just make sure you're putting them on the right schedule. What you need to know in advance is that you really should sit down with the books that you're keeping and revise your bookkeeping processes and your chart of accounts potentially to make sure it's easy for you to distinguish between your ag and your non-ag ventures. This is good so that at tax time, it's easy for you to produce the schedules that you need that are going to be in compliance with IRS regulations. But also, you're probably going to do this anyways because you're going to want to run, profit and loss from your farming ventures and profit and loss from the different aspects of your operation to see what is making you money. Where really is your profitability coming from? That can help you make good business choices. So it's an obligation to the IRS, but it's also just a good business practice. So very recommended to sit down and talk with your accountant and your tax preparer at the beginning to make sure that you are lining up your books to make this information easy for you. Also, talk with your accountant and tax preparer for more information on the deductibility of expenses under Schedule C. You may already know, if you've run a farm for a while, what kinds of expenses you can deduct from your farming operation. Are those the same under Schedule C? Check, ask. Depreciation, does it function the same? So make sure you're not making assumptions based on what you've done for Schedule F for Schedule C. Okay. Intellectual property protection. Let's talk about this one. So you've got a variety of tools that are available to you to protect your business from competition. Competition is a time-honored tradition in the American business landscape, and the tools you have to protect yourself from competition are not designed to be expensive. They are supposed to be more limited because we see competition as a business good, and the courts uphold that, American value of competition. But here are the things that you can do to protect from competition. And I phrase these in terms of your goals because it's easier than explaining it in terms of the tool. If you say to yourself, gosh, I don't want anyone to take my educational resources, my curriculum, the manuals that I use for my consulting. I don't want them to take my artistic designs and do all of this and sell it as if it was their own. This is what copyright is designed to protect. Copyright protects works of authorship. Now, when we think authorship, we're like, oh, so you wrote a book. Yeah, it includes that, but it does, authorship can go beyond writing a book. It's things that are creative and have some tangible nature to them. Like they're not ideas. You created a thing. So books and plays are, the great there, but also architectural works, if you're choreographing anything or pantomiming. Um, and I bring it up because it's funny. These are the things that are protected: jewelry, glassware, tapestries. So it's probably not what you're thinking, but I'd put it in there. Copyright is meant to protect these things, and they give you a claim against anyone else who is using them, even if they're just giving them away for free. That's you have a right to that. So how do you get a copyright? The good news is you already have it. If you were the first to produce that thing, you've got a copyright to it. And if someone else is using it, you can tell them, look, I was the first to do that. I have a copyright. But you can also choose to register your copyrights if you want everyone to know in advance. And that gives you like broader ability to enforce your copyright. You can get more types of damages and attorney's fees and stuff. So if you go in the artistic direction or writing and that sort of thing, keep copyright in mind. Trademark, though, is a bit more what people are familiar with. For this, let's say that you're worried someone else will use your logo or your brand items, your brand identifiers, in order to trick other customers into thinking that they're buying your product. Here is where trademark protection can help. Trademark is meant to protect your business from copycats. Okay, so it is very different in that you must have a business and you must have brand identifiers that are directly connected to the goods and services that you offer. And you do have to register, you don't have to. It is easier to protect your trademark if you do register it. You can register it at the state or the federal level. But keep in mind, again, these are to protect against someone who wants to fool other people into thinking they're selling your product. Now we have a patent. Let's say you're thinking, I have a new invention and I want to bring it to market and I want to stop others who might have the same idea or take my idea. I want to be the one to bring this idea to market. In this case, a patent could be the right idea, and I'm going to leave that one there. We'll cover patents in more detail. But what I'm going to do is I'm going to explore two other intellectual property protection mechanisms that we have. Okay, non-disclosure agreements. Let's say a farmer is thinking, well, I'm worried that a business vendor or an advisor, like I'm worried that my loan officer, you might take my business plan or my product idea for themselves before I have a chance to even protect this thing or manufacture it or develop it or anything. In that case, a non-disclosure agreement can limit that possibility. If you have an idea that's really in the formative stages and you want to speak with a potential vendor, with an insurance agent, with a loan officer, you can ask for a non-disclosure agreement ahead of time. You can say, and these are widely available. You could say, could you, sign this just to confirm that you're not going to, blab around town about my cool idea, before I have a chance to do it, before I have a chance to protect it. Also, trade secrets and competition. Let's say the farmer says, oh, well, all that's well and good. I have another worry. I am worried that an employee will set up their own business just like mine and take my good idea that that they watched me develop in my business. And they're going to take my good idea and they're going to take my customers with them. And they're going to set up another farmer's market stall right next to me and start selling the same tool, or even a different tool, but they're still going to take my customers. Non-competition and trade secrets agreements can help in some ways in this. you have limited opportunity to restrict employees from setting up their own shop that's just like yours. You also can ask your employees to sign agreements not to disclose your trade secrets. And your trade secrets are confidential things, things that you do or use in your business to your processes that you follow, or even things like customers and how you cultivate them, and how you follow your leads and secure your sales. You can protect those things as trade secrets under some circumstances. So what I've done is I've given you 5 very general ways to protect your intellectual property, and each one of those is going to require quite a bit more investigation from you to be able to use it. But hopefully what you gain from that is the word, at least. I need a trademark. Okay, I need a non-compete agreement. And then you can go forward with figuring out how those work. Especially for these mechanisms, I really like some of the resources that are available at public libraries. You can go to the public library and get a book on non-competition agreements. And you can read in there, okay, what are the state restrictions on this? How would I draft one? Same with non-disclosure agreements. These are good products for educational, development. But you can research and investigate how to do that. Okay, I think I missed a question here.
Yes, there was one on an intellectual property, and there's other questions that I think we can get to at the end as well. But for this one in particular, I'm looking at the farmer who had the experience with the California Avocado Commission, who copied some of their video off their social media and recreated it and reposted it for their social media without asking or acknowledging. And she's pays them commission for her sales for the packing. So wondering if that's illegal. Any advice on this case?
Interesting. There would definitely be more to look up and know here. So I just went back to my slide on copyright. These are works of authorship, of video, especially something that you edited, that is a creative product that you put together. Yes, could be protected with a copyright claim, and you have a copyright even if you didn't go to register it anywhere. If you're the first to produce that thing, then you do have rights of the copyright holder, and you could go to them in that instance, of course, depending on the particulars of exactly where this video came from, and say, look, I produced that thing, I own a copyright, you used it without a license, let's negotiate. Let's talk about that and see where you can take it. Oftentimes what folks do in that situation is say, well, a license is available if you pay me XYZ. And that's how they get the right to use your, what's your copyrighted material. They pay you for it. So it opens up that conversation.
Thank you for that. And I know you mentioned using your local library for sources, but is there any free templates or anything you recommend in general for NDAs or waivers too?
Yeah, I recommend Nolo Publishing, Nolo. They have a huge line of materials. Most public libraries carry them. You can also, buy them at most bookstores. They have a great set of educational materials that come with templates and things like that.
Perfect. Thank you.
Yeah, so you don't even need to buy it. You can go to the library and use the photocopy machine and go from there. Okay, I'm gonna get to my business structures material here. And I see we have a patent question coming up. I'm gonna leave that one. Okay, so let's talk business structures. Should you form a separate or an LLC? So maybe you already have one for your farm business and you're thinking, should I do a new one for my software company, for my educational venture, my consulting? Hmm? Well, let's review. What is the purpose of a business structure like an LLC or a corporation in the first place? In the first place, the purpose here is to protect your personal assets from business liabilities. So if we start with the farm could incur business liabilities through a number of ways. You know, the classic we always think of is somebody eats your spinach and gets sick and then they sue you. Oh, that would be a business liability. Another one might be a more commonplace injury where, you back into someone's truck while you're doing a delivery. Your farmer's market stand blows up in the wind and hits someone in the face. All of these things can result in a liability. And if the person gets a successful judgment against you for that, and you don't have an LLC or a corporation, they could take your personal assets. They could say, oh, I see you've got that great truck. I would like that. You know, it doesn't happen very often, but it can. And so, in order to protect those personal assets, folks form a business entity that offers that protection, like an LLC or a corporation. Then, when the person gets a successful judgment against you, what do they take? Your business assets. LLCs and corporations don't protect business assets from business liabilities. Those are still available, and that's why we get insurance. So that when we back into somebody and our, farmer's market tent hits them in the face, they make a claim on our insurance policy. And that's how they get paid, and we don't lose our business assets. So what I'm telling you is, please get insurance. That is your number one risk management strategy. And if you've done that, then let us come back to this question of whether you should form an LLC. Yeah, it's great. It's usually a low cost, easy to do risk management strategy that's going to add that, another layer of protection for your personal assets, which is great. So should you form another one once you start this other non-farm venture? It's a cost-benefit analysis. The cost of forming a separate LLC for your separate venture is the cost inherent in running another set of books. Now your bookkeeper is running in two different sets, and at the end of the year, you're filing, two sets of tax forms to go with that. And, there's administration fees that go with it and annual fees and blah, blah, blah. Your accountant might charge you more now because they're running two LLCs for you. So you got to assess your costs and see what is this going to mean for you with the vendors and service providers that you work for. Then you have to look at it against the benefits. What you're doing is now you're insulating one business's assets from another business's assets. So let's say that now you're running a tool importing business and somebody whacks themselves with the tool, or the handle flies off and it hits them in the face. With an LLC, they have all the assets of that tool manufacturer business available to them if your insurance fails. So now they can take, whatever inventory of tools you have and, the bank account that goes with the tool business, but they can't take the harvest truck that you drive into the fields to get your tomatoes, and they can't take the bank account that's for the farm production business. So you're setting up you're putting this together, this smaller pile of business assets that is available to them, again, if your insurance fails to provide, and now they really are going after your business assets. Different people come to different conclusions about whether to form separate LLCs and how many separate LLCs to form. Here's a rule of thumb that Farm Commons likes to use. The riskier it is, the more a differential in the risk that you're experiencing in these two ventures, and the more the differential in terms of the asset base that you're using for these two businesses. The more different those are, the more you should consider a separate LLC. I made it. It's 6 o'clock, or it's 6 o'clock where I am. It's 4 o'clock where you are. I got to pass it on.
Yeah, thank you, Rachel. I think I do. There are a couple questions that I think are relevant before we hand, and we do have Christine on the call from the U.S. Patent Office who's going to go over some great resources that are available to the community. But I know she's also not in a position to give legal advice or educational awareness on some of the issues. So, Rachel, I just want to get to two questions real quick before we pass it off to Christine. There was a great question that came through earlier around liability with the U-Pick operations, where the customer's picking berries and paying for the berries that they're picking. How does that kind of tie in with what you were sharing earlier?
Yeah. So let's go back to that statement that anyone who does the work of a for-profit business is an employee, unless they're a contractor. Separate issue. Um, so what is the work of a for-profit business? The work of a U-Pick farm, a classic U-Pick farm, and the classic concept is to produce something people want to pick, to make it available for them to pick, to set out the buckets and baskets with which they will pick it, to show them where to pick it, and to take their money and weigh it when they come back with it. It is not the function of a U-Pick farm to actually pick the thing. So anyone who is doing the picking of the thing is not doing the business of the farm. Now, if they were standing at the cash register and ringing up the charges and handing out the change, yeah. If they were on social media saying how glorious the strawberries were, yeah, but not picking the berries.
Yeah. Thank you for that. And these are all great questions too from the attendees. So again, I think we will look into hosting a whole separate webinar focused around the employment law and liability, which I think there's a lot of questions and generated a lot of questions for farms, and I'm sure there's more where that came from. But one last question that then ties into I think what Christine will be reviewing is the copyright versus patent versus maybe licensing versus other options for software. This person asks, is copyrights easier to defend than a patent, or maybe you can just talk more to how to protect software. If you could add more comments to that. Or Rachel, I think that's where because I know Christine is and with the not
Oh,
offering too
sorry.
much advice.
You meant me. I do not know, and that was a great question. I was like, as soon as I read it, I was like, I should have looked that one up, but I didn't think of it. I'm not deep in that software world. Um, so I'm gonna stay away. I'm gonna back away slowly.
Yeah, and we can maybe look into it more too. But Christine, if you also have any thoughts to share, please chime in, and we'll hand it over to you now. If you
Sure.
mind introducing
Hi.
yourself as well. Yeah.
Hi. And can you all hear me okay? Okay, fantastic. Yes, I will touch on that lightly because I do have a couple of thoughts. But first, let me introduce myself. My name's Christine Nelson, and I'm with the United States Patent and Trademark Office. So we're the USPTO. I'm going to share my screen, and I'm going to walk you all through the uspto.gov site. But first, let me just tell you a little bit about myself. I am a regional outreach officer. And so the patent office has regional offices. We have a Western regional office, and that's where I work. So I'm coming to you from San Jose right now, which is where the Western office is located. We serve 7 states, basically everything that touches the Pacific, Arizona, Nevada, Alaska, and Hawaii. So we got connected with CAF by meeting them at the World Ag Expo. It was our first time there. We realized that there was definitely a need for ag folks to learn more about patents and trademarks specifically, and also about intellectual property. So I absolutely love that Rachel covered that and kind of gave you an overview. And hopefully at some point in the future, I'll do some more programming with Kath and with Elizabeth to do some deeper dives into intellectual property and patents and trademarks and what we do and educate you. We have all kinds of resources, but for today, what I would really like to do is just tell you about our website and what some of these resources are that are available to you. So I'm going to start by sharing my screen and want to make sure I get this going. I also realize I have about 10 minutes. I'm an East Coaster. I'm a fast talker and by nature. So if I go too fast, somebody please put it in the chat and tell me to slow down. Okay, Elizabeth, can you see my screen? Okay, and you can see one that says USPTO locations.
Yes.
Okay, fantastic. Okay, great. Here we go. And I promise I will circle back to that software question as best I can. Okay, so um, Elizabeth put in the chat the a flyer that we have, and this was really I think what caught Kath's attention is that we have a resource flyer, and so this is in the chat. You can open this in front of you as a PDF. You can refer to it, and so I'm just going to step through some of the sections on this. Like I said, I'm from the Western Regional Office. So if you can see my cursor, this is where we are, and we serve the Western region. There are 5 regional offices, and our headquarters is in Alexandria, Virginia. Our goal with regional offices and with outreach is to bring this education to our stakeholders, which is you. So it's anybody. We want to demystify the process of getting a patent or a trademark, and also highlight where that might be important for you and how you can figure that out without necessarily investing a whole bunch of money up front to talk to an attorney. So anyway, this is us, Western Regional Office. Tiny little bit about my background as well. I was a patent examiner in Alexandria at our headquarters for 15 years. I worked in medical implants. So my knowledge is more on the patent side, but the Patent and Trademark Office is just that. We're patents and trademarks. So we issue patents and register trademarks. They're 2 completely different processes because they're 2 completely different types of intellectual property. But we're sisters and we're in one agency, and our agency falls under the Department of Commerce. Okay, so there are locations, and if you look at the top of this flyer, the very first things that we have highlighted are some of our educational programs, and I'm going to jump around. I've got some tabs open. I will show you how to get to those tabs in just a second, but I want to show you, oh gosh, this little. Hold on just a second. There we go. Um, Events page. So our website is vast. It's huge. It's deep. It has so much information. It's really easy to get lost, but it's also really easy to find yourself. So how I found this is events. This is events, about us, and home. So this will always show you this kind of blue ribbon will show you where you've come from and how you got there. And like I said, I've just got a few of these pulled because in the interest of time. But if you go to our events page, you'll see what's coming up. And if I just click on some of these, Path to a Patent, Part 5, that's happening tomorrow. I'm actually presenting for that. So if you want to come, please do. You just register. And these are free webinars. They're in real time. They're very much like what you're doing now, although I think your event still goes tomorrow. So and you just hit register and that will take you to it. We have the Path to a Patent series is an 8-part series. It starts with intellectual property basics, and then then it gets more and more in depth or in the weeds or detailed as we go along. So tomorrow I'm going to be talking a lot about claim construction and what a claim is in a patent and diving a little deeper into that. We also offer this series quarterly. So the schedule is on the Path to a Patent page. And there we go. Upcoming events for Path to a Patent. It's going to show you the next series when it starts over at part 1. So, I'm sorry, these are past ones, but upcoming. And then once it concludes with part 8, it will start over again. There is another series called, let me get back to events, called Trademarks Bootcamp. Trademarks Bootcamp is really the same kind of thing. It's a series of webinars, but focusing on trademarks. So if that's something that you're more interested in, you can attend the trademark series. Also, this is all free. Everything on our website's free. All of our educational resources, all of our webinars are free. So no cost to you at all. And now you're thinking, oh my gosh, I don't know whether to go to the patents one or the trademarks one, where do I even start? Well, we have a tool for that too. So we have something called our IP identifier. And this is basically, where do I start? You just go through, you answer questions, you click through, and it'll help you try to figure out, like, is this something that would require a patent, a trademark, a copyright, or maybe it's a trade secret? And I'm looking at more of those non-disclosure and non-compete elements. Um, so, so yeah, another great resource just on our homepage. I think we have a link to that. We do. It's the first one on the top of the back sheet of that little flyer that we have in the chat for you. We talked some about the events page and some of those educational programs. Let's talk a little bit. I know there was a question about fees, and that's a very, very good question. So fees, our fee schedule is on our website. Again, seeing how we got there, home. So, oh, let me show you our homepage. Sorry, I jumped straight to that, and I never did show you the actual homepage. This is the homepage. And from here, again, all kinds of different places you can go, but it is a little bit overwhelming. So if you get lost, you can just go into the search bar. I'm going to put fees. I'm going to search it. And there we go. Voila, USPTO fee schedule. That's the page I was just on. So tons and tons of fees. This is super intricate and super confusing. But what I want to highlight for you is there are fees. There are small entity fees, and they're significantly less. Then there's micro entity fees that are even less than significantly less. So, so how do I know if I'm a small entity or a micro entity? Let me see. I'm looking for where I have that pulled up already. There we go. So there's a page for that on uspto.gov. And this describes what a small entity is, less than 500 employees. This describes, and some other considerations. You absolutely must meet all of the considerations to make that small entity status. But there's also micro entity status, and these are the considerations for being a micro entity as well. So I would definitely say don't be intimidated by the fee schedule. Check it out as far as seeing where you fall. Again, so many resources. There's one more I just want to highlight. I know I'm running out of time here, but I wanted to highlight that we do have programs in Spanish as well. So trying to find that one, free resources. Here we go. So if that's something that's beneficial to you or to anyone in your circle, you can come and learn about the fundamentals of patents also in Spanish as well. So I think I'm out of time. I wanted to quick hit that question about a patent or a copyright for software. So for software to be patented, it can be patented. Absolutely. And it can be patented. There are several just different types of patents. And so it might be a method or a process, or it might actually be the code itself, which might be more of a trade secret, or that might be a copyright if you've written the code, or if it's attached to a medium like a hard drive or some kind of a tangible medium, then it might fall into another category for patenting. So we always use the example of a cell phone. So this lovely device has all the different types of intellectual property in one device. So software is really a tricky one because it can fall into a lot of different buckets depending on what you're looking for. And I would encourage you to start with that IP identifier tool and just spend some time on our website looking at the patents, doing a deep dive into patents. As you can see, the big buckets here are patents, trademarks, policy, and then learning and resources. So hopefully that did it. It's right at 4:15 on the nose. I'm going to stop sharing. And I'm just going to hope that I get to come back and talk to you all some more and do some more intellectual property education in the future.
Thank you so much, Christine. And yeah, I know we threw her into the mix last minute after we made that connection at the World Ag Expo. So really appreciate you being available on such short notice to present to us. CAF is going to look at holding another webinar just on IP basics for folks and maybe going over trademarks, copyrights too, and the differences of that. Sometime in May is what we're considering. So any attendees on the call who are interested in that, just stay tuned for CAF's events and the listserv and get notified of those upcoming webinars. And Rachel too, I think we're going to have to bring you back for liability and employment law, just 1 hour workshop on that, because I know there's so many farm unique situations that come up. So really appreciate you too. Thank you. That was fantastic information sharing. So just thank you for going over all that. And yeah, Evan, is there any closeout or anything to do here next for wrap up?
Thank you all for coming out. And we hope to see everybody else at the final virtual workshop of this year's conference, which for those of you who are here, check it out. It's the award ceremony for the Innovation Challenge. So stick around, check it out, and we hope to see you soon.
Thank you.
Thank you.